It's time for today's Legal Minute with the Law Office of Cooley, Shrair, and Springfield. We're joined by attorney Bob Dambrove. We're talking about sexual harassment in the workplace. Let's get a definition working, though. What is sexual harassment in the workplace?
Okay, well, first there's both a federal law and a Massachusetts law that you can file for protection from sexual harassment. Sexual harassment means sexual advances, sexual requests for sexual favors, or other conduct of a sexual nature where the submission or rejection is a condition of employment or it forms a basis for employment decisions, such as if somebody is fired for refusing to engage in sex requested by their supervisor. That's called commonly quid pro quo harassment. Another form of sexual harassment is when the working atmosphere, the workplace atmosphere, is so sexually charged that it becomes intimidating, hostile, so offensive that it interferes with a person's ability to perform their job. That's commonly called hostile environment sexual harassment.
If someone feels as if they've been a victim of either one of those forms of sexual harassment, what can they do to begin the process of rectifying the situation?
Well, first they ought to complain to their employer. Most employers have sexual harassment policies. In fact, in Massachusetts, by law, employers of 6 or more employees are required to have a sexual harassment policy. If that doesn't resolve their problem, they can always file a complaint with either the Massachusetts Commission Against Discrimination or the Equal Employment Opportunity Commission. You only have to file it one, because whichever agency receives a complaint, they automatically file with the other agency. And then there's a procedure to follow then.
Well, thank you so much for the tips. Hopefully you can
thank you.
Help make people's lives a little bit easier out there. That's your Legal Minute. And for more information, you can call 413-781-0750 or just visit Cooley Shrair online at cooleyshrair.com.